Sexual victimization of people inside the United States is a critical social issue. It is an issue that is of great importance and it brings about a lot of emotion from everybody. We have seen in the past, Louisiana and Texas have both attempted to attach pedophilia and child molestation to the death penalty as a punishment. And that has been ruled unconstitutional, but it is still a topic when we discuss sexual victimization and crime within predators who are seeking sexual fulfillment or power and control or whatever. We have a strong emotional response from the rest of society. The National Crime Victimization Survey indicated that rape and sexual assaults were well represented in the victimization surveys. And such, in 2010, they reported 268,570 rapes and sexual assaults. That has been declining and has been decreasing throughout time, but there is a lot of sexual victimization that's going on in our country. The National Child Abuse and Neglect Data System shows that 62,000 children were sexually abused in the United States in 2010. This is epidemic proportions. And as a way to protect society and protect our children, we have come up with a sex offender registration notification process. Okay. Prison statistics reveal that more and more convicted sex offenders are being incarcerated across the country. Incarceration rates of sex offenders have increased by 48% throughout the years. This episode is going to be discussing sex offender registration and tracking those who are sexual predators. The purpose of the sex offender registration list is to alert local law enforcement officers as to the whereabouts of sex offenders within their jurisdiction. It has also been expanded to let the community know where the sex offenders are in their community, living within their neighborhood. Is a way, and it was viewed as a way to protect citizens from further sexual victimization. Congress passed originally the Jacob Witterling Act in 1994 in a reaction to the 1989 kidnapping of Jacob Witterling, an 11-year-old boy, and his body has never been found. Okay, the federal law requires states to create a sex offender and child abuse registry. Offenders are to be tracked for a minimum of 10 years beyond the release of incarceration or any punishment. Okay, there's also some legislation that requires a lifetime registration for chronic offenders and those offenders who have committed heinous sexual offenses. Megan's Law was passed in 1995 that amended the Witterling Act to require communities to implement notification measures when a sex offender is released from prison and moves into the neighborhood. This is through door-to-door leaflets, through mailings, or notification in the newspaper, even postings at the local courthouse, to identify and to let the community know that there is a sexual predator on the grounds in the neighborhood and around the other family children. Pam Lyncher, or the Pam Lynchner Sexual Offender Tracking and Identification Act of 1996, was legislation that required lifetime registration for repeat offenders and, again, for those who particularly committed particularly heinous and ugly and violent crimes. In 2000, the Campus Sex Crimes Prevention Act was passed, requiring sex offenders to report their registration requirements to any institution of higher learning in which they become employed or enrolled in classes. And those lists have to be made public and established and sent to the professors and the student body of who the sex offenders are. This has continued through our history. Offenses have been expanded for registration on the sex offender list to include kidnapping or imprisonment of a child, solicitation of a child, or actually engaging in sexual performance with a child, solicitation to engage a child in prostitution, video voyeurism involving a minor, possession, production, distribution of child pornography, criminal sexual conduct involving a minor or the use of internet for the same, and any conduct by its very nature is a sex offense against a minor. The Walsh Act, also known as the Sex Offender Registration and Notification Act, enhanced the penalties associated with crimes against children. The Walsh Act attempted to create standards for sex offender registration and notification. It increased accountability for the registered sex offender with punitive sanctions for those who failed to register. All of this, all of these laws were enabled by a strong sense of outrage among the victims' families. In the case of Pam Lichner, her family members and herself, and the community at large. You can still hear, people in the community asking for the death penalty and asking for those who molest children and those who sexually violate other citizens of our country to be adversely punished for their activities and their crimes. An argument and pushback that has come against the sex offender registry notification legislation has been the argument that it is a violation of individual privacy rights because of court cases like Roe v. Wade and Greenwich v. Connecticut, where the courts have established and have ruled that the 14th Amendment guarantees us privacy to live our lives the way that we choose, that forcing a sex offender to register as a sex offender and to notify the community that he is in the neighborhood is a violation of the 14th Amendment and the Constitution of the United States for the rights to privacy. The courts have rejected that argument over and over and over again. Whether it's Connecticut Department of Public Safety versus Doe, Smith versus Doe, Doe versus Portitz, the court has consistently stated that there is no violation of due process rights associated with Megan's Law or any of the other registration legislation that exists to this point. Even before SORNA or after SORNA or since SORNA, they have not had any cases that has stated that registration and legislation is a violation of due process or privacy rights. Another pushback and complaint about the sexual registration notification legislation is that it's a violation of the equal protection. And the argument states that sex offenders are not treated the same across the country, and in each different state and each different local jurisdiction, they have different expectations, and different offenders are not treated equally. For example, in Illinois, sex offender register is only a 10-year period. California requires sex offenders to register for life. Texas, you can register for 10 years or for life, depending upon the heinousness of the crime. And there is no uniformity from state to state to state. So the complaint is that it's not fair and it's not part of due process because of the Equal Protection Clause. Okay. Alexander in 2004 argued that sex offenders' equal protections are violated since murderers, arsonists, and other felons are also sent to prison to serve their time, and then they're released from prison with no further incarceration, no further civil commission, or otherwise having to register with local authorities as being a murderer or a thief or an arsonist or anything else. The only people that are treated this way are sex offenders. And according to Alexander, this is a violation of due process. The courts have not made an answer on this as of date. They are just relying upon Doe versus Ports, Carr versus United States versus Kibido. Another argument that exists against the sex offender notification registration legislation is its efficacy. And the claims are that it doesn't really work very well, and it doesn't work in the way that it is intended to work in protecting society from sex offenders. What Brooks in 1996 and Steinbach in 1995 have stated is that outed sexual offenders have been violently attacked. They've been faced with hostile demonstrations in front of their homes while in and out and about the local neighborhood. Wagner in 2011 reported that some sex offenders have been murdered by community members, envisioning the monsters of old being chased down by the villagers with pitchforks and rails and tar and feathers. Steinbach in 95 stated that most child molestation is perpetrated by family members, not strangers. And thus, forcing a sex offender to register only increases their punishments. And it's not intended in any way to protect children from becoming victims of sexual abuse. It is only set up to humiliate the sex offender. Because if most molestation occurs within the family, everybody in the family is going to know who the molester is, and there's no need to continue notifying the rest of the society because other kids' children are not in danger. Focusing more specifically on outcome-based research, a study done by Schramm, Darling, and Malloy in 1995, they followed 125 sex offenders for 54 months. They were subjected to community notification and a comparison group of 54 where there was no community notification were tracked over the time of 54 months. They stated that there was no significant differences found between the two groups, although those offenders in the notification group were arrested more quickly when a new crime did occur than those that were in the non-notification group. Okay. Also, a retrospective design looking at 136 diagnosed repeat offenders by examining their criminal records concluded that 27% had arrests for previous sexual offenses, and of those, only 1/3 had been perpetrated on a stranger. Most of them had been perpetrated on a family member, thus suggesting that the registration and notification legislation is not very effective in preventing future sexual criminal crime. The number of sex offenders who are failing to register is higher than once thought. In Massachusetts, we found that there was evidence of over 30,000 high-risk sex offenders that were unable to be located by local authorities because they had not registered with the local community, they've given false addresses, or they've not updated their contact information when they moved from one home to another, suggesting that the registration legislation is not very effective and is not helping the community stay safe. In the world of civil commitment, the United States Supreme Court has upheld the state's right to civilly commit a sex offender over and over and over again. it has been determined and assessed that if a sex offender has been diagnosed to have a psychopathic personality disorder, that person can be committed and held indefinitely. These cases illustrate the continued support by the Supreme Court of state civil commitment for statutes of sexual offenders. It should be noted that all of these cases begin with legislation that has defined violent predatory sex offenders. The violently sexual or the violent sexual predator is defined as a person who has been convicted of a sexually violent offense against two or more victims who have been diagnosed with a mental disorder that makes the person a danger to the health and safety of others, in that it is likely that he or she will engage in sexually violent criminal behavior in the future. Kansas versus Hendricks is the key leading case on this that addresses the 1994 Sexually Violent Predator Act. And the courts came down with a ruling stating that defining due process rights. The court concluded that there is no absolute right to be free from restraint from the government when there is cause to believe that the individual poses a danger to the larger society. 2, the requirement of some sort of mental disorder prior to the restraint is in alignment with the previous court decisions. 3, the fact that treatment community disagrees with the state of Kansas on the meaning or nomenclature surrounding the term mental disorder is not a reasonable defense, since the court has never required states to adopt a common meaning or definition of such terms. 4, since the commitment of Hendricks falls under civil proceedings, the double jeopardy clause of the United States Constitution is not in question, as that prohibition applies only to criminal proceedings. 5, the purpose of the commitment is to monitor Hendricks until such time he is no longer perceived a threat to society. So the purpose of the statute is not punitive in nature. 6, even if Hendricks is not amenable to treatment, the court has in the past upheld the civil commitment of individuals under the philosophy of incapacitation. Thus, Hendricks' argument that the state is further punishing him, knowing he cannot get better with treatment, fails, and, similarly, ex post facto clause pertains only to criminal proceedings, not civil proceedings. The court has determined time and time again that a civil commitment to protect the greater society from sexual predators is acceptable. In United States versus Comstock, the court actually extended civil commitment beyond the end of a prisoner's sentence if he or she is considered to be mentally ill and sexually dangerous. Using the clear and convincing evidence standard, not a beyond a reasonable doubt standard. Necessary and proper clause of the United States Constitution allows the civil commitment of individuals who are deemed a danger to the greater society.